Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the first of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay. So any official acts, then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right. So my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in, because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is, in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question before my colleagues take it over here? At the beginning of your analysis, when you were giving your opening statement, you were talking about you suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is, at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution," and everybody cried out against that.
No, I understand, but since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted. Counsel.